The Illinois Eavesdropping Act has been in place since 1961, and technology has overtaken this law. So says the Illinois Supreme Court. They say it's far too broad. They threw it out, meaning our legislators down there in Springfield will have to find a balance, cobble together some sort of legislation that will protect people's rights, because even nowadays they said that this law was so antiquated and so overreaching that if you were using your cell phone to tape a crowd cheering at a sporting event, you would have been committing a crime. Let's begin there with Joe Lopez, the Shark, who joins us this morning on our Turnkey.pro answer line. A woman, Amy, spent 2 years in jail, I guess, because she had recorded a Cook County court official over the phone without telling this official that they were being recorded, and she got thrown into prison for 2 years, so this worked out in her favor at least. Hi, Joe. Welcome back to the program. Let's talk a bit about this eavesdropping law. Is this a good move by the Illinois Supreme Court?
Yes, good morning. I think it's a very good move by the Illinois Supreme Court. I mean, the statute was just so overbroad and encompassed all kinds of innocent activity, as you noted earlier in the opening, and it's about time they actually took a look at it and found that, you know, it is unconstitutional because it is so overbroad, and what that really means in layman's terms is it includes a lot of innocent conduct as well as illegal conduct.
Well, before it was thrown out, what was our state statute on this? Could I record police officers? Could I record a conversation with you with one-party consent, or did I need two-party consent?
Well, you need a two-party consent. You know, the Alvarez case a couple of years ago from 2010 when the ACLU came in and tried to declared it unconstitutional in federal court because people were recording with their phones what police officers were doing out on the street. The Seventh Circuit Court of Appeals in the federal court says, you know, the same thing. You know, this is overbroad, and if it's conduct on the street, you don't need their consent because there's implied consent when you're out on the street. So I think that what the Supreme Court did was it took a look at that and found that, yeah, that in fact happens every day with people to have their cell phones out. If you're recording your neighbors having an argument next door in the backyard, that would have been illegal under the old law.
But don't we have an expectation of privacy?
You know, when you talk about expectation of privacy, when you walk out of your house, you kind of abandon your expectation of privacy when you're out in the public, whether you're at a sporting event or having an argument at a barbecue with somebody. It's called implied consent. So when you're out on the street, there really is no right to privacy because you expose yourself to the public.
What if you're in someone's backyard and they have a 7-foot-high privacy fence?
Well, you know, this is a question a lot of people ask, and you know, the Supreme Court says you don't have a right to the air above your house. So if someone's flying over your house, or if somebody their bedroom windows above your fence line, they can look down into your yard, there is no right to privacy because they can see what you're doing.
So let's go inside the house now. Much like the woman who taped the Cook County court official without permission, if somebody calls me beginning today and they do want to record me, they no longer have to tell me that they're recording the conversation, correct?
That the way that the current state of the law is, yes.
And do you think that our legislators downstate will find some sort of balance? Because a lot of folks think, and I include myself among them, that if somebody calls you on your phone and they're recording the conversation, we should be made aware of that.
Well, you know, that's a good point. However, you know, when you talk about cell phones, these are basically radios. So you know, the big question is going to be the difference between, you know, a landline and between a cell phone, because, you know, when you're on a cell phone and you're using it, there is implied consent for somebody actually to hear that. Anybody with a receiver that knows how to zero in on a phone conversation can record it. The question is, can the police record it without a warrant? That's going to be the new question.
As a reporter, I mean, a former reporter, I should say, when we would need to get some information, you could go to Indiana or to Wisconsin because it was one-party consent.
Right, and one-party consent, there's a few states that do have it. Federal court has it. In the federal system, it's only one-party consent.
Wait a minute. You would go to Indiana and place a call back into Illinois, and that would give you coverage, James? Mm-hmm. So you just drive over the state line, use any landline, I assume, to prove you're in Indiana, which is a one-party consent state, and call back into Illinois to sabotage somebody.
Not to sabotage. To investigate.
To investigate. To bushwhack them.
We call that to overhear them.
Yeah.
And capture it.
Well, how do you feel about it personally, Joe? I mean, you're in the business of information, and you have to deal with a lot of confidential things between you and your clients, all the ne'er-do-wells that you represent. I mean, now anybody can listen to those conversations without informing you.
Well, the only problem with that is, we do have the attorney-client privilege, and one of the things that they did invoke in the lower court when this woman recorded the court reporter is that there always has been the crime exception in Illinois. You could record somebody without their consent if you thought you were getting evidence of crime. Mm-hmm. So it raises all kinds of different issues as to how the legislature is going to have to take a look at this, and they're going to have to do a series of different types of scenarios and try to figure out how they can apply this law and make it stick based on this new decision.
Boy, this woman, this Annabelle Malongo, one of the defendants here, I mean, it's unbelievable to me that she spent 2 years, almost 2 years in jail when she was charged under this 1961 law. Who was representing her, and how bad was that malpractice?
Well, that's raised a lot of issues with the Cook County Criminal Defense Bar. We found out that she wrote her own motion. They call it a pro se motion. For some reason, her lawyers didn't file the motion. She had to actually file her own paperwork to get herself out of it. So we don't really know too much else other than what we read and why the lawyer didn't file it. But it's kind of odd that an attorney wouldn't file such a routine motion. That's usually the first thing you do when you go into a case is you try to knock out the wiretap or you try to knock out the search. You fight the probable cause issues. Apparently, her attorneys didn't do it, and she had to do it herself.
So, how long ago was the incident? I wasn't able to find out how long ago she taped this Cook County official, and then she spent 2 years in, and I assume it's been several years as this worked its way up through the Illinois Supreme Court.
I believe it was in 2010, if I remember correctly.
Wow. Well, before we let you go, I have one question in regards to if you're in someone's backyard, there's a privacy fence up.
Here we go.
What if you use a recording device to zoom in? Isn't that illegal?
Again, when you're in your backyard and you expose yourself to the air above you, I don't think that you have any right to expect that no one would see what you're doing. Now, if you're in your garage and they peek through an open door, that might be a different situation.
Okay. All right. Well, thank you very much, Mr. Lopez.
Yes.
Joe, where can we follow you on Twitter, sir? Can we get your Twitter handle one more time?
Yes, it's JOSHARRK.
Follow the Shark on Twitter. We thank you for your expertise. Your analysis is always welcome here, and have a great day, Joe.
Thank you, everybody. Bye-bye.
Bye-bye. Joe Lopez. So long, everybody.
Bye-bye.
Joe Lopez on our turnkey.pro answer line.